Sir, given that the intent was not to package the code as a fresh opportunity for creditors and claimants who did not exercise their remedy under existing laws within the prescribed limitation period. The committee thought it fit to insert a specific section applying the Limitation Act to the code. The relevant entry under the Limitation Act may be on a case-to-case basis. It was further noted that the Limitation Act may not apply to applications of corporate applicants as these are initiated by the applicant for its own debts for the purpose of CIRP and are not in the form of a creditor's remedy. A perusal of the above would show that considering that the Limitation Act applies only to courts unless made statutorily applicable to tribunals, the committee was of the view that such act should be made to apply to the IBC as well, observing that though the IBC is not a debt recovery law, the trigger being default in payment of debt would render the exclusion of the law of limitation counter initiative. Thus, it was made clear that an application to the IBC should not amount to resurrection of time barred debts which in any other forum would have been dismissed on the ground of limitation. From the above, it is clear that the principle of Section 9 of the Limitation Act is to be strictly adhered to, namely that when time begins to run, it cannot be halted except by a process known to law. One question that arises before this court is whether Section 18 of the Limitation Act, which extends the period of limitation depending upon an acknowledgement of debt made in writing and signed by the corporate debtor, is also applicable under Section 238A, given the expression as far as may be governing the applicability of the Limitation Act of the IBC. The aforesaid question is no longer valid as two recent judgments of this court have applied the provisions of Section 14 and Section 18 of the Limitation Act to the IBC. Thus, in Seshnath Singh VBD Cooperative Bank Limited Civil Appeal Number 9000 of 2019, after setting out the issues that arose in that case in paragraph 57 and after referring to Section 238A of IBC,